everyone, we are here with another session today, or today is 28th of July, or marking many things which are important today. If you all guys are following, let us go for first update. जो लास्ट टाइम भी मैंने बोला था, अभी तक जिसने RTNLU पे रजिस्टर नहीं किया है, जाके रजिस्टर कर लो as soon as possible, क्योंकि फिर डेट्स निकल जाएंगी, आप रजिस्टर नहीं कर पाओगे. So make sure you register to race to NLUs. ठीक है, अगर ये अभी तक नहीं किया है तो अभी जाके रजिस्टर करो. ठीक है, गो ASAP एंड रजिस्टर फॉर द सेम. बाकी डू फॉलो द न्यूज़, whatever is happening around, just follow it, and if you have any opinion, do let us know in the comment box, and I think you guys know what I'm talking about. Moving on, the first thing that we are going to discuss is PCI social media and digital ethics guidelines. So there are many interns, and then there are advocates, and then there are proceedings that are going on, and then everybody has that that वो जो एक kick होती है to become an influencer and everything. So for that they have come up with guidelines to what should each of them record and what should not. A considered institutional response, not a new code. It's not a new code, but applying existing professional obligations to the digital sphere. Legal bases are Section 735 and 49 Advocates Act 1961 rules, 36 PCI rules, and judicial trigger being Anil Pandey versus BCI. The Supreme Court is sending a notice on digital self-promotion. प्रोसेस सेफ कमिटी 8 जून 2026 को बनी थी. जनरल काउंसिल अप्रूवल गॉट ऑन 11th of July 2026. व्हाट इज़ प्रोहिबिटेड? तो प्रोहिबिटेड क्या क्या है इसमें? मेजरली प्रमोशनल रीजनल क्लिप्स, मोनेटाइज लाइव स्ट्रीम कॉन्टेंट, AI सिंथेटिक कंटेंट, confidentiality breaches, lawyer live content, and legal misinformation. So if we go into the details, promotional reels, courts की premise, proceedings chambers inconsistent with professional ethics हैं, so you cannot go and make the reels. Monetize live streaming content, clipping, editing, sensationalizing, अगर आप ये सब कर रहे हो, that is also prohibited. AI synthetic content, deepfakes, voice clones, face swaps, falsely depicting judges, courts or litigants, right? Then we have case strategy, pleading, settlement, communication, chamber discussion, privilege extends to internship. Lawyer live content, day in court / chamber, post by students that trivializes work or breach confidentiality. Fake judgments, fabricated citations, false testimonial, fabricated citations, fake judgments हम देख रहे हैं AI के. That AI usage के ऊपर भी recently कोर्ट ने बोला, because this is coming up, right? Again and again. क्योंकि हम AI को बोल देते हैं, advocate being advocates AI से सारा काम कराने की कोशिश करते हैं, and then AI gives the false judges and judgments and the citations. What remains permitted is legal awareness. आप legal awareness फैला सकते हो, responsible legal education कर सकते हो, constitutional literacy, accurate reporting कर सकते हो. Academic discussions अगर हैं तो law updates हो गया, scholarly commentary होगी, not misleading or promotional. Students participation, legal literacy and academic forums, not holding out as an advocate or authorized practitioners. मतलब जो students हैं जो intern करने आते हैं वो actually are not the practitioners, they are just the interns, and they should be treated like that only, right? Permitted content must not be misleading, promotional, or sensational in nature. Compliance and enforcement architecture would be affidavits, institutional duties, state ethics committees, BCI nodal cell, applicant students pre-interns submit undertakings, nodal officers handle complaints, preserve evidences, and CLEs run sensitization and keep records. Coordinate with platforms and intermediaries. Enforcement is classified into minor, serious, aggravated breaches. जैसे हम if you read Juvenile Justice Act, you get the serious and aggravated things, right? Similarly, that in that sense, the acts are not same. First of all, just the definitions would be same. Okay, the level of definitions would be same. That is what I'm trying to tell. Prevention of Insults of National Honor Amendment Bill 2026. So Home Minister Amit Shah introduced the bill as item 8 under government legislative business. What he's trying to do, extending criminal protection to Vande Mataram on par with Jana Gana Man. So extra protection towards the same. The amendment will take place in Section 3 of the Prevention of Insults to National Honors Act 1971, criminalizing intentional prevention of the disturbance to the singing of Vande Mataram. Historical context written by Bankim Chandra Chattopadhyay in 1875, published in Anand Mat Constitute Assembly, Rajendra Prasad, 24 Jan 1950, accorded it to equal honor, never given statutory protection until now. So legislative momentum would be a 10-hour Lok Sabha debate on 150th anniversary during winter session 2025. So for BJP, national song deserves partly with national anthem, 150 years commemoration, 150 years on sung nationwide. Against CPIM, Article 91A, 25 freedom of conscience, 21, 2014, and constitution avoids compulsory patriotism. One nation, one election is here again at the talk of the town, examining the Constitution 129th Amendment Bill 2024. Declared the framework constitutionally sound after 9 state consultation, including Goa and Lucknow. Mechanical framework, we can see key constitutional amendments, Article 82A, 83 and 172. President notifies appointment date to commence synchronized cycle. Duration of parliament and state legislatures are aligned. Then Article 324A and 325, simultaneous local body polls, common electoral poll. Phase 1, amended to sync Lok Sabha and State Assembly elections from 2029. Article 324 enables Panchayat municipality elections within 100 days, and premature dissolution triggers elections only for remaining of term preserving synchronization. UT laws amendment bill extends framework to Delhi, Pondicherry and J&K. The numbers in the debate: 71 CR projected savings, 1.6% GDP boost, 32 out of 47 party support, 81% public support. So against arguments are for the 4, जो 4 के ऊपर इसके arguments होंगे: one nation one election, reduced election expenditure and policy disruption जो हर बार होता है, right? Uninterpreted governance, a model code of conduct relief. India held simultaneous polls for first 4 general elections. Arguments are against threat to federalism. S.R. Bommai, the basic structure जिसके अंदर doctrine is always discussed. S.R. Bommai case को एक बार देख लेना, it is a landmark judgment, go and read it, right? Marginalization of regional parties, national narratives dominant, and short-term tenure governments increased Article 356 risk. Final law faces Keshav Nanda basic structure challenge. So basic structure should not be hampered, and that is it for today's session. I really hope you are going to go and discuss all the 3 topics. Read them. This PPT would be available to you on your Telegram channels. Go and get the PPT from there and try to read all the 3 topics. And that is it from my end. Thank you guys. Bye-bye. Take care.